Jehovah's Witnesses lose the privacy law appeal here in British Columbia, BC, Canada. So we're going to take a look at that article and see what happened. Okay, so here it is. It's in the Victoria News. Grand Forks Jehovah's Witnesses lose their privacy law appeal. So a couple Jehovah's Witnesses wanted their records from the Kingdom Hall, and Jehovah's Witnesses said no. So it went to court the first time, and the judge said, yeah, you can view your records. There's nothing says that that's against freedom or their religion. So Jehovah's Witnesses appealed it. So here's where we're at. The court rules against Jehovah's Witness appeal to withhold the former congregants' personal information. There's a picture of the Grand Forks Kingdom Hall in BC here. And an appeal by Jehovah's Witnesses in Grand Forks over holding the personal information of two former congregation members has been dismissed and is being hailed as a victory for the privacy rights of individuals. So Jehovah's Witnesses lost. Now, the BC Court of Appeal ruled unanimously on March 21st that BC's Personal Information Protection Act, PIPA, did not infringe on the religious freedoms rights of the two congregations of Jehovah's Witnesses. So that's what they're fighting this on, is the Religious Freedoms of Rights Act. Jehovah's Witnesses like to hinge on some of this stuff. And it says the case started in June 2022 when two former Jehovah's Witnesses requested access to their personal information under the control of the Grand Forks and Coldstream congregations. Now that's kind of where I live. I live in the Coldstream area here right now. So it'll be interesting to see if this is done, if these guys get their records. Let's see what happens. While the congregations and their elders have fought to keep certain information, arguing disclosing these records would violate their charters of rights, of religious freedom. Imagine that, hinging on that. Charter of Rights of Religious Freedoms. Well, the Jehovah's Witnesses will try anything in court. Now it says, according to the judgment authorized by Justin Karen Horseman, PIPA does not violate the Charter of Rights and Freedoms. The BC Court of Appeal rejected the Jehovah's Witnesses' claim that a blanket exemption is constitutionally required for all information collected for a religious purpose. And the Court of Appeal upheld a Chambers judge ruling to compel the Jehovah's Witness to produce the records, citing that the Privacy Commissioner and the adjudicator can decide constitutional claims on a case-by-case basis. So the appellants submit, in essence, the adjudicators ought to have taken at face value their assertions that the disclosure of the disputed records would constitute an unjustified infringement of the Charter, the ruling reads. And such an approach does not involve a balancing of the Charter protections with statutory objectives, but rather accords with priority in every case to an organization's assertion that a production under order would unjustifiably infringe charter rights. And it is tantamount to the type of categorical exemption from the legislation that I've already concluded is not constitutionally required. What a mouthful. Well, if there's a way of wording this in court to win Jehovah's Witnesses, that's what the courts did here. And they favored on the side of the ex-Jehovah's Witnesses, the guys that wanted, the people that wanted their records. That's all they wanted was their records, to see what's in their records. So it says an adjudicator for the Privacy Commission and the Chambers judge in the lower level of court both largely ruled against the congregations, leading to the most recent appeal. And with the latest appeal, the BC Humanist Association joined as an intervener to advocate for the privacy rights of former religious adherents, particularly those who left high-demand religious groups. So folks, there's also the BC Humanists have ran this article as well, the privacy law, so it's a big thing, and they stood up for the two ex-Jehovah's Witnesses. The articles are the same. I'll just continue to read it here in the Victoria News. Now it says, in a news release issued after the decision was published, The association stated they argued privacy and religious rights are for individuals, not incorporated organizations, and that privacy laws address the inherent power imbalance between organizations and individuals. And this is a good decision that recognizes the importance of every British Columbian's privacy rights, said Ian Bushfield, Executive Director of the BC Humanist Association. He says, "Our concern has always been the protection of vulnerable individuals who may face significant consequences when their personal information is shared without their consent, especially," he says, especially within the context of the religious discipline. The Jehovah's Witnesses could take an appeal to the Supreme Court of Canada. They're famous for doing that. They love going to court. They love litigating. So they could appeal this to the Supreme Court of Canada. And if they do not, they will have to disclose the disputed records to the Privacy Commissioner for review to decide what information can be released to the former Jehovah's Witness congregation applicants. So that's where we're at on that, folks. Jehovah's Witnesses lost in the court of appeal here in Canada. So we'll see what happens. Will they take it to the Supreme Court? So stick with us. If you haven't subscribed yet, please subscribe. It helps push the channel. Thanks for watching tonight. And if you have any news of your own, you want to email it to us, you want us to read your story, mail it to us at mail@xjw.tv, and we will certainly get that. So thanks again, folks, and keep living your life with love. We'll see you on the next video. Bye for now.